Namaste, and today is a Saturday, 8 p.m. Indian Standard Time, and welcome to our Legal Words of Wisdom, Nyay Gyan Ganga, on our Virat Hindustan Sangam social media channels. As you know, on Saturday, we keep discussing on various legal aspects and educate the common man on the legal and law issues. Today, we will be discussing the defamation and how it can affect you, part 2. As you know, last Saturday, we discussed in part 1 some of these civil defamation issues. In the last episode, we looked at what is defamation and how it presents a threat to journalists and others. This law has two dimensions, civil and criminal. Fortunately, both civil and criminal defamation laws provide for certain defenses which protect potential targets. What are those defenses? How can they be used effectively? What happens when someone loses a defamation case? Why are criminal defamation cases so popular in India? These are some of the issues that will be discussed in this episode. As you know, we have Dr. Subramanian Swamy, patron and president of Virat Hindustan Sangam, and Dr. Venkat Iyer, who is based in UK, who is an Indian origin barrister and who has been in the forefront of educating the legal fraternity on various aspects of the legal system. And he has been, since the last 9 episodes, today the 10th episode on the Virat Hindustan Sangam channels, that he has been telling our viewers on the various aspects of the Indian law system and how effectively one can take advantage of it. And we have Dr. Swamy, a living example of not being a lawyer, but at the same time having been successfully used the Indian legal system to get justice and in his fight against corruption and for Hindutva. So with these words, we are today discussing the second part of our defamation issues, and Dr. Swamy will do the introductory remarks, and it will be over to Mr. Venkat Iyer, Dr. Venkat Iyer. And as you all know, we have a legal Gyan Ganga or Nyay Gyan Ganga every Saturday at 8 p.m. Indian time, and we have a regular Gyan Ganga Words of Wisdom on Sunday also at 8 p.m. So we thank our viewers for their support. I have to thank my co-host Ramesh Swamy for being active to help us in putting this program together, and our technical team led by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Rakesh Gadgi, Tejas, and Swaminathan from Chennai for their background support to put this weekly program together. So with these words, it's over to Dr. Subramanian Swamy.
Well, thank you very much. We today go on to other aspects of defamation law, which we discussed last time. The fact of the matter is that it's a living thing for most Indians, and it's a kind of a nightmare for those who don't know the law. What happens is somebody files a case against you. He can file a criminal case or a civil case. And the difference is that if it's a criminal case, then you are called an accused, and you are expected to come and take bail. And for a law-abiding middle class, this is a very pain in itself. The second thing is that you are all kinds of things are said about you to shake what they call is your credibility or your truthfulness and so on. So a lot of things that they come. And the third is, which is I think perhaps the one most distressing for most people, you have to rely on a lawyer. And these courts, especially the lawyers on both sides have a a professional understanding that if we ask for an adjournment, the other side doesn't really seriously object. And so they have to, anyway, the lawyers, generally speaking, they should not be, but it should not be so, but they charge you fees whether the case goes on or it doesn't go on. There are, of course, a lot of good lawyers who say, when they see a really just case, they say, no, I won't take anything. Or they say, well, after winning the case, whatever you feel like you give me. There are people like that, but that's very rare. The main thing is you have said something which in normal conversation, would not be objected. Is supposing I say somebody's a nut case. That's a very common, part of the common verbal abuses that people say. And if you say to another person, and that person acknowledges to somebody else, and then ultimately it reaches the person whom you have called a nutcase, he can file a defamation case. And then you have to keep going to court. Sometimes there are long distances to go to court. And it's quite a harassing process. So what we have been trying to do here is demystify the defamation case particularly. Other cases like collective bargaining or damages suits and so on, they're not so it doesn't take your nervous energy so much. But I have found from other people that defamation cases make people very unhappy, and because the kind of abuses that are poured on you inside court, where the lawyers have a liberty to say so many things which they cannot say in normal public discourse. So I have enjoyed defamation cases after the first one. And Jagdish I was a young boy that time, and he had accompanied me to a defamation case filed by Jethmalani, and the unfairness of it was it took out an extract of what I said in Indian Express, which was published in the Chandigarh edition. But the Jethmalani's argument was that Chandigarh edition comes by post to many of us, and we read it, and he produces witnesses saying that yes, I read the Chandigarh edition, and it was all made up. But then have to prove that all this is so. So, but in the course of that, I learned how to fight a defamation case. And even that one that Jethmalani began by fighting, and 3 others in his lifetime, all he lost. The Hegde lost. I mean, I have not lost a defamation case. And on the other hand, I've made people admit, express apology. And the latest one was in the United Nations, where the number 2 senior most official of the UN, the Under Secretary General, made some defamatory remarks about me regarding the CAA, the Constitutional Amendment Act, and the question of why Muslims were not included in that list. And I pointed out that under the Constitution, equality doesn't mean anybody is equal to anybody. It is equality of equals. I can't say that women should not get rights because we are men and women are equal. Well, in certain circumstances, we do give them rights. Or reservations for scheduled castes. How can you be when there's equality? Well, it's not. They are not equal. It's not. We are not equals. So it's only equality of equals. So many other things you get to learn, and therefore in the United Nations, this Under Secretary General held a press conference and denounced me for a cut and paste job done by a Pakistani television network. And so we issued a defamation notice, and Mr. Ishkaran assisted me in that. And then, lo and behold, the United Nations was astounded, because there are very few such cases that come, because United Nations officials usually have what they call as immunity. But there was a conference, and some of the veto-holding countries had a conference. They decided that it was very unfair for what this Undersecretary did. but they did not publicly say so, but they terminated his tenure, and so my case collapsed. In the case of a Congress spokesman, Mr. Sanjay Jha, he said that the WikiLeaks says that I'm a CIA agent. So I filed a defamation case for 1 crore, and it was a suit. It was not a criminal case. And this distinction, I think Venkat has already said, but we might repeat it just now. And there, where the WikiLeaks, unfortunately, for Mr. Sanjay Jha, denied that they have ever said this. They never said anything of the kind. And so he had to apologize. So the Congress spokesman, the height of my doing the 2G spectrum case and the hatred which Sonia Gandhi had for me at that time for what I had done to her, and in the National Herald case got, the arrest warrants issued in their name and they had to take bail. At that stage, Mr. Sanjay Jha had to, as a spokesman of the Congress Party, apologize in writing, and which I accepted, and the case ended. So I think every Indian should strive, because it acts on your freedom of speech, and you have to be unduly careful to learn the defamation law and learn to go to court and fight for yourself. Then it's enjoyable after some time. And then after that, nobody wants to file a defamation case against you. Only Jayalalitha filed defamation case against me, many, and she has lost every one of them. If I counted you, you would be shocked. A total of 125 cases Jayalalitha filed over a period of 5 years against me, and she lost every one of them. And yet she ultimately became my friend. She came to my house and said, apologized, and Jed Malani also, in the end, apologized to me and said he went to court, told the court also that the service that Dr. Swamy has done for fighting corruption, I feel that I've done a mistake in filing these defamation cases. And the fourth one, 3 he had lost, but the fourth one he withdrew. So it is in a victory because this case was dismissed. So what I've taken this extra time to say that please listen very attentively to Venkat, because he's extremely knowledgeable in this field, and therefore you must make a resolve that you will learn defamation law to the point where where you will not have to depend on a lawyer for this particular litigation. I'll conclude by saying that in the Hindu, I had written an article which went viral at that time. It's most read op-ed, and that is how to win a defamation case. And I'm sorry, I should have told our people, Jagdish and others, reminded them that this happened about maybe 15 years ago or 18 years ago, something like that. And that I've told how people can themselves go and fight a defamation case. Over to you, Venkat. Sorry to take up so much of your time.
In last week's episode, I tried to indicate some of the key principles of defamation law, and I dealt almost entirely with civil defamation. My discussion was, of course, far from exhaustive, given the enormous scope of the subject. And as Swamy pointed out last week, defamation is an area of law to which not even 10 episodes will do complete justice. Indeed, when I do training sessions on defamation for professionals, that is, lawyers, judges, media editors, etc., in various parts of the world, each event would normally extend to a minimum of 3 full days. But we don't, of course, have anything like that amount of time. So I shall, in the course of today's episode, try to wrap up the discussion, dealing first with some unfinished parts of the civil law, and then devoting some time to criminal defamation. If I'm able to address any issue which strikes you as important, but I'm not able to give it enough time, then please raise it via the comments box, and either Jagdish or Ramesh will try to bring it up during the discussions which will follow my talk. Let me take up briefly a couple of things that came up last week, which I could not deal with properly due to lack of time. First, Jagdish's point about certain builders in Bombay filing criminal defamation FIRs against flat purchasers who have complained about defects or defaults on the part of the builders. My hunch is that most of those FIRs are intended to harass or intimidate the complainants, in which case, those at the receiving end should apply for the FIRs to be quashed summarily by the magistrates who have jurisdiction over them. I want to reiterate a point that I have made repeatedly, namely that there are enough provisions in Indian law to deal effectively and firmly with frivolous or vexatious legal proceedings. And I would say that if there was a clean, efficient, and competent judiciary, it won't be long before the message gets through. But in fairness to the builders, it is also possible that some disgruntled flat purchasers may go over the top and make reckless allegations, sometimes adopting blackmail tactics, in which case they need to be proceeded against as well. This can also be done properly if there was a functioning legal system in place, which unfortunately there isn't in many parts of India. Secondly, in relation to the situation concerning criminal defamation in two jurisdictions to which reference was made in passing last week, the US and Singapore. As I had surmised but could not immediately confirm, the situation in the US is a bit complicated because although there is no federal law on the subject, I understand that as many as 23 states and 2 territories do have statutes, and one state deals with the subject through common law. As for Singapore, no, it has not abolished criminal defamation. In fact, the law there is exactly the same as in India, namely Section 499 of the Penal Code, which they borrowed from India. And also, this section has been used a fair bit, uh, leading to a lot of protests and a campaign for its abolition. The third thing I wanted to clarify is that Mr. Morarji Desai had in fact filed a civil defamation suit in India as well. This is in addition to the one that he filed in the US, about which Swamy spoke last week. And what happened in that Indian case was that unfortunately he died before the suit was heard, which led, of course, to its abatement. My recollection is that his lawyers tried to get an injunction against the publication of the book in India while Mr. Desai was alive, but failed because, generally speaking, if the defendant in a defamation suit argues that he'll stand by the allegations and prove them to be true, an injunction will be refused, as long as the court is satisfied that a prima facie case for truth has been made out. This is an important principle which needs to be remembered. So, if you wrote something about someone and you can prove the truth of what you wrote, then the target of your comment cannot normally stop the publication of the book. Although, of course, uh, if you fail to prove the truth of the allegation at the trial, you'll have to pay significant damages. Given that cases in India take decades to be heard, most litigants always try to get an injunction, and if they succeed, more than half the battle is won, sometimes undeservingly. This is particularly true of big companies who try to suppress criticism of their activities by seeking injunctions against the publication of unfavorable media stories. Uh, Continuing on that theme, I want to talk first of all about the various defenses that are available to anyone facing a libel suit in India. The most effective of these defenses is, of course, truth or justification, as it is called technically. Uh, to take an example, if you wrote an article in which you accused a politician of corruption based on solid evidence that you gathered using, let's say, a sting operation which you had carried out, then any case filed by the politician against you will fail. And truth is a complete defense in civil law. In criminal law, truth is only a defense if it is coupled with the public good, which reduces its force somewhat. But there is an important qualification. It is that the burden of proving the truth of any alleged defamatory statement is on the defendant. This is a departure from the normal rule that the burden of proof is always on the person bringing a case. In practice, the reversal of burden of proof has profound implications. It means that you should not say some defamatory things about anyone unless you have solid proof of the allegation that you're making. Mere honest belief in the truth of your words is not enough. Now, generally speaking, the law only requires you to prove that what you have alleged is substantially true, not necessarily fully true. So, for example, if you had alleged that a doctor was incompetent and that he had performed 6 operations negligently, leading to the deaths of all the patients, but you only have proof for 5 of those 6 operations, you may still be able to win any defamation case that is brought against you. What is substantially true will depend on the facts, of course, of each case. But if you had accused someone of being a habitual or serial liar, and you're only able to prove that he had lied once, your defense will fail. Habitually or serially means more than once. That is a pattern of behavior. Another rule is that if you make multiple allegations and you're only able to prove some but not all of those allegations, you will win the case as long as you can prove the most serious of the allegations. At least that's the case in England, and I venture to think that that is also the case in India. To take an extreme example, if you accuse someone of murder and of jaywalking, and that person is convicted of murder but acquitted in a jaywalking case, now you will, in those circumstances, escape liability for defamation. Remember also that no matter how unfair your allegation against someone may be, you will escape liability in civil law as long as you can prove the truth of the allegation. A second important defense is fair comment. Here, the defendant will argue that what he said amounted to an honest opinion, that is, fair comment, on a matter that had been submitted for public scrutiny. This defense is most helpful to journalists, for example, when they criticize people and institutions in editorials or say unfavorable things in reviews of books or films and so on. Remember that we are talking here about comment or opinion, not statements of fact. And it would be impossible to prove or disprove the truth of comments or opinions because they are always subjective. But the law has certain tests to judge whether a comment is fair or not. Again, to take an example, suppose you write an article saying that a certain doctor is a disgrace to the medical profession and a danger to society. It is, of course, a comment that you're making, but there must be a basis for that comment in the public interest. That basis may be a report, for example, of the medical council, in which the doctor in question has been held guilty of professional misconduct after he had behaved inappropriately with female patients. A very important limitation to fair comment is that the comment should not be vitiated by malice. So, if you wrote a review of a book and you savaged the book with particularly strong negative comments about its publisher. And it turns out that you had had a nasty fight with the publisher immediately before this happened, because it turned out that the publisher had rejected a manuscript that you had submitted for publication. In those circumstances, your defense of fair comment is likely to fail. In other words, you must come with clean hands. Also, the comment in question must have relevance to the context. So, if you wrote a review of a book which was about, say, music or biology or philosophy, but you added falsely and completely gratuitously that the author of the book was a wife beater, the defense of fair comment will fail. Another important defense is absolute privilege. Here, the law recognizes certain occasions when, no matter how defamatory your statement about someone is, they will not be allowed to sue you. The best example of this defense is when a member of parliament makes a defamatory statement from the floor of parliament. Even the most reckless statement is exempted. I don't want to give people ideas, but if you're a journalist, you can use this provision of law effectively as long as you can find a friendly MP who is willing to say in parliament what you want to say outside but cannot for fear of a defamation suit. But obviously, what can be said in parliament will be subject to the discipline of the House and to the control of the Speaker. In relation to privilege, I would draw your attention to Article 105 of the Constitution. Absolute privilege will also incidentally apply to fair, accurate, and contemporaneous media reports of court proceedings. Yet another defense is qualified privilege. This applies to certain situations like evidence given in a court. If you say something defamatory about someone while giving evidence, you cannot be sued, as long as what you say is relevant to the case and not actuated by malice. Qualified privilege also arises when you say something which may be defamatory about someone in a reference that you're writing about him or her, say to a prospective employer. Here, the law recognizes that you have a duty to be frank, and the recipient of the reference has a duty to receive a frank assessment of the candidate. This defense was a couple of decades ago extended to journalistic writings in a case called Reynolds and Times Newspapers Limited in England. But that case, as far as I have been able to find out, has not been adopted in India, even though references to it have been made in a few judgments. Qualified privilege is also available to journalists when they publish fair and accurate reports of court proceedings, but not contemporaneously. There is one more defense, namely consent, but it is less frequently used. It means simply that if you write something defamatory about someone who has not complained before publication, in spite of knowing about it, they are deemed to have consented to the publication. It can arise in celebrity interviews where you say something about what a film star has said. For example, a film star boasting to you about certain disreputable things they may have done, and the boasting happens during the interview, and they may have had an opportunity to read the transcript of the interview before publication, but they feel ashamed about those things after the interview is published and try to sue for defamation. The media outlet can, in those circumstances, defend itself on the ground that the film star had consented to what was said and what was published. I need to tell you about one important rule in defamation litigation. You will have heard Swamy talk repeatedly about the role of discovery and interrogatories in lawsuits generally. But when it comes to defamation, there is a limitation. If you sue someone for libel, you cannot, as part of the process of discovery before the trial, ask the defendant for any confidential sources that they may have, because that would mean compelling them to reveal their defense prematurely. It would also mean that there's a risk of defense witnesses being nobbled, that is, dissuaded from testifying. Also, it's always a good idea for parties in defamation litigation, whether plaintiff or defendant, to be civil and reasonable in their pre litigation correspondence. Because otherwise, there's a chance of the damages awarded being increased to take into account unreasonable behavior. Moving on to damages, then, there are a few principles which I shall describe briefly. First of all, there are presumed damages. This is given to compensate the victim for the damage presumed to have been caused to his reputation, and this will be based on evidence provided about, say, loss of earnings. Secondly, there can be special damages given to those who may have suffered particular harm or loss. For example, the breakup of the victim's marriage as a result of the defamation. Thirdly, there can be damages for mental anguish relatable to the humiliation, anxiety, or distress caused by the defamation. Fourthly, there can be what are called exemplary damages against defendants who have acted with actual malice or who may have behaved very unreasonably with the plaintiff. Fifthly, there can be nominal damages where the court thinks that the harm caused to the plaintiff is not serious, but a message is still to be sent out to the defendant. And finally, there can be contemptuous damages, for example, 1 rupee, awarded when the court believes that the plaintiff, despite winning the case, himself behaved unreasonably or disgracefully or should not have brought the case in the first place. The calculation of the quantum of damages is, as I said last week in answer to a question from Ramesh, a very complex process, and it is well nigh impossible to offer an accurate guess most of the time, which is why defamation litigation is frequently called a gamble. Generally speaking, in torts, only damages to compensate the plaintiff for the loss suffered by him are given. Exemplary damages are awarded in rare circumstances. I can think of two. First of all, when there is oppressive action by public officials, and secondly, when the defendant engages in conduct that is calculated to make himself a profit, which may exceed any compensation payable to the plaintiff. For many years, England was seen as a place where libel law was applied in a plaintiff-friendly way, and people were awarded huge damages. That led to London being referred to jokingly as a town called Sue. But all that changed recently, I would say in the last 10 or 15 years, and nowadays damages are more modest, comparable to what someone would get if they won a personal injury case. The number of high-profile defamation cases has come down, and instead, quite a few people have begun to sue for invasion of privacy, about which I intend to talk in a later episode. Incidentally, one of the cases in which a record amount of damages was paid involved the writer and former politician Jeffrey Archer, who I notice is quite popular in India. He got £500,000 in 1987, but had to return all that money with interest 15 years later, after he was found guilty of attempting to tell lies on oath in the original trial. If anyone wants to know more about this colorful case, we can discuss it during the Q&A, which may follow this lecture. Talking of damages, the highest amount awarded in India used to be 1.5 lakhs of rupees for a long time, arising out of a famous defamation case called Takasi and Karanjia. This was heard in Bombay, and this case involved the now defunct weekly Blitz, and it resulted in a trial in the early 1960s lasting some 101 days, and an appeal which lasted for I think 30 days in the Bombay High Court. But that record of damages was, of course, broken, not least by the Sawant case to which I referred last week. I noticed that it is now becoming fashionable for some plaintiffs to claim 1,000 crores in defamation cases. And the reason why they're able to do this brazenly is that beyond a certain amount, the court fees payable is capped, and people can indulge in their fantasies about what they claim. I personally consider this to be an unhealthy development. So, to recap, the main remedies available in defamation suits are damages and injunctions. The court can also order the defendant to remove any defamatory matter that has already been published. One more point before I move on to criminal defamation. Can a person who already has a poor reputation sue for defamation? The answer is yes. At least that is the answer in principle. For example, if you have a bad professional reputation, say as a builder, but someone falsely accused you of being a sexual predator, you can certainly win damages because your professional and personal reputations will be treated separately by the law. However, if the defamatory allegations were connected with your already bad reputation, then the chances of your succeeding in a libel case are very slim indeed. This is what happened in an interesting case involving an American uh, baseball player called Lenny Dykstra, who tried to sue another player called Ron Darling, but failed miserably because the court termed Dykstra as a libel-proof plaintiff. His reputation, said the court, was so toxic that it was impossible to defame him anymore. So let's now look at a few things concerning criminal defamation. First of all, why is this type of legal action so popular in India? I would say partly because it produces results quicker than a civil suit, typically 7 to 8 years rather than the 25 or 30 years that it takes for a civil case to be heard. Everything is relative, of course. 7 to 8 years would be considered scandalous in most decent countries, but in India it's almost super fast. I cannot resist the temptation to recall what my old guru Nani Palkhiwala used to say on this subject, and I can recall very clearly the statement he used to make, and that was that a lawsuit once started in India is the nearest thing to eternal life ever seen on this earth. The second reason why criminal defamation is popular, at least in India, is I think because of the human tendency for vengeance or retribution. If you succeed in a criminal complaint, you have the satisfaction of getting your tormentor punished, ideally with a jail term, which of course you cannot get in a civil suit. I also think that some people file criminal defamation complaints simply to harass those whom they don't like, because it is possible for the defendants to be made to attend court, sometimes in distant places, over an extended period of time. Incidentally, the punishment for criminal defamation is simple imprisonment for up to 2 years, with or without a fine. There are, of course, very strong arguments for the abolition of criminal defamation, and it is a pity that Swamy's effort to have it struck down by the Supreme Court did not succeed. My own view is that it would be much better if Parliament decided to repeal sections 499 and 500 of the IPC, but I guess it may be difficult to get the necessary parliamentary majority to achieve that result. In the meantime, there is a way out of the problem, and it has to do with magistrates taking a tough line on such cases and throwing out summarily those cases which are unmeritorious or frivolous or vexatious. And I know that they have ample powers to do this under existing law. But this will only work if magistrates themselves are given extensive training on defamation law, which I think needs to be carried out on a war footing and on a national scale. That said, as long as the law stands, we'll have to contend with what we have. I've already indicated the ways in which criminal law differs from civil law insofar as defamation is concerned. Just to recap, first, criminal action can be taken in relation to defamation of dead persons, as long as the allegations are defamatory and intended to be hurtful to the feelings of his family or other near relatives. In this regard, there was a case in the Punjab and Haryana High Court just a week ago where someone tried to bring a prosecution arguing that his dead spiritual leader had been defamed. The court, rightly in my view, throughout the case, saying that since he was not related to the dead person, he had no locus standi. Secondly, in a criminal action, what can happen is that you can bring a complaint for defamation of a group of people, what the law calls a collection of persons. But that group has to be clearly identifiable, and the person complaining must show that he has been affected in some serious way by the defamation. The provision of law for criminal defamation, which I've referred to, namely Section 499 of the IPC, is quite long. It consists of many explanations, illustrations, and exceptions. These exceptions, and there are, I think, about 10 of them, are actually defenses, and they're not substantially different from the defenses available in civil law. Many of the defenses are variations of privilege of one kind or another or fair comment. Needless to say, a huge volume of case law has been generated over the years under the criminal law of defamation as well. To wrap up this discussion, I thought it'll be a good idea to know what can be done at a practical level to deal with defamation cases or threats of such cases. So, if you're a journalist and you want to write a risky story, you need to ask three fundamental questions before you publish your story. First of all, is what you're going to say true? Secondly, can you prove the truth of what you're going to say? Or do you have any other any other defenses? And thirdly, how likely is it that your intended target will sue you? Remember that nowadays almost everyone is in the position of a journalist because of social media. And the one other point I want to make is that all the rules of defamation law which apply to traditional media, that is newspapers, books, films, TVs, etc., also apply in exactly the same way to the new media, that is social media or online media more generally. Yes, there are differences when it comes to procedure and enforcement. For example, how do you deal with the challenges of anonymity? How do you sue someone who may have defamed you from outside India, sometimes from obscure countries which don't even have a recognizable legal system? If you decide to sue them locally, that is in India, and you get a judgment or an order in your favor, how do you enforce that judgment or that order? These are all extremely difficult questions to answer, but if you're talking purely of domestic defamation, the substantive law is the same for traditional and new media. Now, returning to practical matters, a lot of the time, defamation risks can be minimized by simply making sensible alterations to the wording of a story. It is important, therefore, for you to know the basics of defamation law, and if you don't know, I think you should make an effort to find out, as Swamy has been saying repeatedly. One other thing, and I'll finish. If you're criticizing a product, you should take care to confine your criticism to the product only and not attribute dishonesty or other motives to the maker or seller of the product, unless you have strong proof of such motives. Remember what I said earlier, companies can also sue for defamation. The final point I would make is that there is a difference in law between defamation and other risks, such as contempt of court, invasion of privacy, hate speech, etc. Even though they are broadly similar, at least when looked at from a layperson's point of view. Over the next few weeks, I plan to talk about some of those other matters, but I'll stop here for the present. Thank you.
Dr. Swamy, you can ask your questions first.
Questions, because it will be in an exhaustive analysis. In criminal defamation law, which you Venkat had referred to and said about exceptions. There's one exception I think I should like to read, which is a very interesting one, which I think the reader must know that that's also a form of defense. First exception, imputation of truth, which public good requires to be made or published. It is not defamation to impute anything which is true concerning any person, if it be for a public good that the imputation should be made or published. Whether or not it is for public good is a question of fact. So in criminal law, truth is not a defense entirely. It has to be accompanied to show that there was a public good served by making that. So you may know something. Supposing I know that somebody is an adulterer. What is the public good in making that public? So therefore, in the criminal law, there's that limitation. The truth is not enough of a defense. It's necessary but not sufficient. It becomes sufficient when you can show there is a public good in making this truth known to the people. I think, in a sense, it impinges a bit on the privacy question. Now, the second thing is that in the United States, and I've tried to bring this in Indian law, I've made an oblique reference earlier here in this proceedings of that we are having. They said that politicians, public persons, so on, they are all well-to-do people. They should not be allowed to sue for defamation, because in America there's no criminal defamation. Sue for defamation, sue for damages for defamation, unless they first show that it is untrue and that the maker of the defamation knew it was untrue and yet he made
actual malice
imputation. That's right. That the term used by the US Supreme Court is actual malice. So now, no politician in the United States, and that's the mistake that Moraji Desai made. They said that there's no public purpose served if by challenging claiming that somebody has defamed you, when it is not any defamation to be a CIA agent for an American. So he went and filed in America with the advice of his son, which was a disastrous defamation. So I'm saying that we also need to bring that in. I tried it very hard. In the civil law, it has been obliquely brought in by Jeevan Reddy's judgment in the Nakiran case called Gopal versus the state of Tamil Nadu. Raj Gopalan case, yes. But I mean, he is the editor of the Nakiran,
yep,
which is a lousy magazine. I'll be happy if he takes me to court on defamation for running the lousy magazine. But then, of course, I'll rip him apart. Okay, so the second thing is there is more defamation of you takes place in a defamation case than if you didn't file the defamation case. In other words, people should balance. I get a lot of requests. This fellow has defamed you. Why don't you file defamation case again? What do I gain? He gets prominence. He enables him, so on. So I think if we are ever going to have another session on this matter, we should address this question: when should you file a defamation case? And two, whether it should be civil or it should be criminal.
Yep.
That's it. Anything else?
Absolutely.
Ramesh or Jagdish?
Yeah, Dr. Swamy, I just want to show. I mean, the article that you wrote in Hindu, this was in 2004.
Yes.
Yeah, the Defamation Litigation of Survivors kit. So on another note, I mean, Venkat, I sent you a case a couple of days ago, Krebs, right?
Yes.
So you said that even jest, you mentioned fair comment and all the other conditions. So in jest is also a condition. So if somebody said in jest, is that, so what category does it fall under?
Okay, that particular case would fall under a number of categories, but there are principally two angles to that case which are worth exploring and which I think will almost definitely result in the dismissal of the case. The first is...
Why don't we, because Dr. Swamy is not aware, it's just you and me that are aware.
Okay, maybe actually, Ramesh, you can explain the circumstances of the case. It's an American case.
Yeah. So what happened, Dr. Swamy? The Krebs, who was was an NSA guy who said when President Trump said that the voting machines were hacked, he said none of that sort. So when that happened, one of the guys said that he should be brought out into the street and shot. Okay, so he made this statement. So on a TV show. And they said it was more like so this guy, when he got fired, has filed a lawsuit against the person who said that on TV. So in short, that's what is the case. So go ahead.
Yeah. Okay. So let's take the jest part first. What he actually said, as reported in the news item that Ramesh forwarded to me, is that this chap Krebs deserves to be hung, drawn, and quartered, which, of course, as you know, is a medieval kind of punishment, and that is the kind of treatment he deserves for whatever he has said or done. Now, obviously, nobody is going to take that seriously in the sense that the practice of hanging, drawing, and quartering is something which ceased to exist centuries ago. Nobody will take that literally. There's no way that can happen. What he was trying to say, the writer, was that Krebs deserves to be condemned. That is really the effect of what he said, and that is not by any means defamatory. But more importantly, for the point that Swamy just mentioned, the case will be dismissed because Krebs is definitely a public figure under American law.
Good. So
even football players are considered as public persons.
Correct. That's why they use the word public figure and not prominent politician or anything like that. So it could be sportsmen, film stars.
Earlier it was called public official. Then the Supreme Court went on expanding case after case.
Correct.
So anyone who is appeared in the media is enough to be a public figure.
And it particularly affects people who seek publicity. There is one more category of people, these attention seekers, who then complain if somebody says something they don't like, that they've been defamed. In which case the answer is, you brought yourself into the spotlight. Why then are you complaining now? Which is a very fair way to address that problem.
But another question for both of you is, I know you've explained between civil and criminal defamation, but where is the line? Is there a line drawn? Or let's say, for example, somebody files for a criminal defamation. Does the court or the judge says this is nonsense? This is not a criminal. You can file a civil, or he just files a defamation and the judge decides whether it's criminal or civil.
Each
No,
judge, whether civil or criminal, is unconcerned with the other court. In other words, if you go to a civil court, it is not for the judge to advise you whether a civil suit is appropriate or a criminal complaint is, or both. The judge will only deal with what is in front of him or her. So if a fellow is foolish enough to try his luck in both courts, and they have to be separate courts, there cannot be in any jurisdiction a case that will be heard in both courts without separate approaches, if you know what I mean. So you have to go separately to each court. And generally speaking, each court is not influenced by the decision of the other court. This goes back to a very fundamental point, which I explained, I think, in my first episode, which was, I think I gave you the example of what's his name, the O.J. Simpson case, where, he or the people who filed against him filed both civil and criminal cases. The criminal cases were lost, but the civil cases succeeded, and they got, what was it, 27 million or something like that.
Money.
Yeah. So they are two completely separate matters, and no judge will say, "Why did you come to my court? You should have gone to the other court."
Okay. And has any court in India? Sorry, go ahead, Jagdish. Go ahead.
Ramesh, only also when you plead or give your written submissions, you have to justify what section of the IPC, like this in case is 499 and 500.
500,
You have to quote that, and in a what you say in a civil suit, you will have to plead accordingly that way. So all that is there in the pleadings or the plaint or the complaint. While it is a plaint in far as the civil suit is concerned, and a complaint as far as a legal suit, a legal thing is concerned.
Okay. So,
also, the starting point is different. If you want to file a criminal complaint, you have to file an FIR or a complaint before a magistrate. Not
you go and you file it in the
magistrate's court,
in the criminal court, and you will be examined first. See, this time when I won these cases, some of them, I think 3 of them are dismissed because saying that there's no defamation. But in 3 of them, I think that Jayalalitha had used the government to file a case against me. It was a crime against the government. So who filed it? The public prosecutor filed it. So under the criminal law, the public prosecutor has to be examined, being a complainant. The complainant is a public prosecutor. So I said he should be summoned to be cross-examined. So that public prosecutor would have been a humiliation for him to be, sitting in the box and me cross-examining him. So he started pleading. And it is at that time the court, and then he started saying, I'm helpless in this matter. I've been assigned to it. I had nothing to do with it. So it became very easy for me to get it dismissed. That this is a frivolous petition and without application of mine.
So has any defamation suit gone all the way up to the Supreme Court, Dr. Swamy, in India?
Oh, they are. I'm sure they are.
Okay.
And I don't remember any. Which went to
be interesting.
I will say that when I filed a public interest litigation, it was saying that criminal defamation is unconstitutional because it puts unreasonable restriction on my free speech. That time, Rahul Gandhi was in a terrible fix in Pune, in a Maharashtra court, for having called RSS a murderer.
Some murder of Gandhi, correct.
Bhiwandi court.
That's right. So he came in and pleaded himself in my case. And I was in a dilemma. If I win, he benefits. If I lose, I lose an important case. So ultimately. I lost. So he had to go back and apologize
Okay.
for made that comment, and the RSS let him go.
Dr. Swamy, could you tell our viewers about the latest victory of yours in on the defamation matter in the Madras High Court?
See, in our criminal law, if you defame a public official, then the state can represent you. That is, the person whom I have defamed need not go and file a case. The government and through the government, for that there is a sanction to be given. The principal secretary or the chief secretary gives the sanction that yes, this is a fit case for filing a defamation case, criminal case, or a civil suit. And therefore, gives a direction to the Advocate General in a state or the Attorney General to go and file it. And he then calls the public prosecutor and says, go and file it. So he goes and files it. And then a summons is sent to you. And if you get those summons and you comply with it, then the first thing that happens is you have to take bail. And that's a messy affair because it has a negative connotation. So I have never taken ever see every time there's a criminal defamation against me, I bring in some issue which I say is a preliminary issue which has to be decided before I can consent to participate in these proceedings. And so on that basis, sometimes the magistrates court or the sessions court doesn't agree. Then I go in High Court. This is what I did with all the cases of Jayalalitha. All of them were criminal cases. I took it to the High Court saying that this is the misuse of authority, and it is not a criminal case that is to be filed by the state at taxpayers' expense. It must be filed by Jayalalitha herself. Now, one case was that I said Jayalalitha, giving her the government is like giving a garland of flowers to a monkey, or the Kapoor essence to a donkey. What will a donkey know about Kaide ki Kalpura Vasna enna theriyum? So that's the Tamil. I said it in Tamil, and it was translated by Jayalalitha for the court. And a monkey, if you give a garland, it'll just tear it to pieces. So therefore, I compared it to a monkey. So she said this is a crime against the government, and therefore she filed it. So this is one. Two, and I don't know how officials could give sanction on such things. I said that our fishes are disappearing from the Gulf of Mannar because motorboats are being used for catching fish, not fishermen's wooden boats, and this is digging into the terrain of the bottom of the after the water, what is called the lower part, the land part of the sea, and so fish eggs are all being destroyed. And these mechanized boats belong to Shashikala. So Jayalalitha couldn't care less. She told us, chief secretary, principal secretary, go file a case. And they went and filed it. No application of mind. How Shashikala can get that protection? It is meant for a public official. Third one was that Jayalalitha gave permission to the LTT. One guy called Dilipan or someone, he went on a fast unto death against the IPKF and then he died. So the LTT remnants in Tamil Nadu, in Chennai, wanted to celebrate, have a function for his memory. And so Jayalalitha's government gave permission. So I attacked her, saying that she has no love for this country, this. So that, and like that. These kind of frivolous things, and so all six of them the court held is not a offense against the public duties of Jayalalitha, and two that they have that my petition that the public prosecutor should be summoned, because in a criminal case, the person who files the complaint, he is the one who goes to the box, and he's cross-examined. He is examined and then cross-examined. So the public prosecutor, so the court wanted to share, not go into that area at all and pass an order which would be a precedent. So they decided on the initial basis that there's no public, her duties as a public service was never defamed. It's personal to her, whether she's a donkey or a monkey. And in fact, the Supreme Court, this matter had come up earlier when I was arguing about the abolition. And the Chief Justice asked the Tamil Nadu Council, who's now a judge of the Supreme Court itself, Nageshwar Rao, that tell me, Mr. Nageshwar Rao, is Jayalalitha objecting to be called a donkey or a monkey or both? So the whole court went into laughter. So, I mean, that was the kind of thing. It's a gross misuse of the state machinery. And I intend now to sue the Chief Minister for continuing to pursue with that case in reckless disregard.
It might also be helpful for you to know that there is a very important case of the House of Lords called Derbyshire, which complete ban on any defamation cases brought by government. Any defamation cases.
I had raised this in the Supreme Court, but I think our Chief Justice at that time was a very timid man.
Deepak Mishra.
Deepak Mishra. So we let it go because the BJP government opposed me.
Oh.
The Attorney General came and opposed me because for them this is the way of blackmailing. I mean, terrorizing people.
Yeah.
Any critic of file a defamation case, let him run around courts.
Yep.
You're muted.
So that's normal, right, Dr. Swamy? Most of the government use these defamations or these kind of threats to.
That is why I want the American public official thing or public figure thing. In civil law, it's already there.
Yeah.
Of Jeevan Reddy's judgment.
Using Sullivan.
But criminal law is where it should come because there you're being deprived of your freedom. If you're found guilty, you're deprived of your freedom. Now, for saying something, you go to jail. It's barbaric. In fact, in most countries of the world now, even Singapore, by the way, Karthi Chidambaram tried, but they said no, criminal law is no more. I think you please check. Singapore has given up.
No, Swamy, the criminal law defamation is still present in Singapore. What Karthi did was he sued you under civil law, and Singapore courts were vigilant enough to see the danger even there.
No, that I know. But I think I was told that there is no criminal law.
No, it's still there.
Next time we are on the that they have recently, as recently as 2013, they have given it up. Even Britain has given up criminal law.
Britain has definitely given up, but not Singapore. In fact, there are so many cases filed just recently in Singapore which are so controversial that the campaign to abolish Section 499, because it's exactly the same penal code, Singapore, Malaysia, Sri Lanka, quite a few countries. And so they're trying to get it abolished. It has not yet been abolished.
Okay. All right then. So, because they have been brutal. Anyone anyone says anything defamatory about any businesses in Singapore, Singapore wants to protect its reputation. So they are very harsh. And there was one leader of the opposition, a Tamil, he rotted in jail.
Jayaratnam. Jayaratnam.
Oh, Jayaratnam. That's right.
Okay, Jagdish ji, we can.
Find out.
You're muted, Jagdish ji. 1 second. Huh?
Sorry,
Okay,
I'm
yeah,
sorry.
okay, go ahead.
Another important and interesting episode in our series of our legal Gyan Ganga and Nyay Gyan Ganga and legal words of wisdom comes to an end with this second part of the defamation series, especially dealing with the um, criminal defamation. I thank Dr. Subramanian Swamy and Dr. Venkat Iyer for their useful inputs in this discussion. We will be back next Saturday at the same time, 8 p.m. Indian time, for another episode of this series which we are continuing. Tomorrow we will be back with 8 p.m. on our normal Sunday Gyan Ganga Words of Wisdom. I thank our viewers, which is spread all over the globe. And you must be seeing from comments some people saying good afternoon, so that means the sun is shining in that part of the world, so that is why they are saying good afternoon or good evening depending on which part of the globe our viewers are watching, because we have viewers all around the globe watching and appreciating the initiative of Virat Hindustan Sangam. I thank my colleague Mr. Ramesh Swamy and our technical team headed by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Tejas from Pune, Rakesh from Bangalore, and Swami Nathan from Chennai for their useful teamwork to putting this program together. Thanks once more to Dr. Venkat Iyer and Dr. Swamy for this interesting episode. Thank you, Jai Hind, and Dhanyavad.